Hello, welcome to this video on battery. So again, a video on non-fatal offences, another type of a non-fatal offence, and indeed a building block to some of those offences as well. Our aim said, of course, as ever, are to distinguish between assault and battery first, to explain the actus reus of battery, the mens rea of battery, and you should be able to apply the law of battery to polling questions, as we deal with in another video. So the introduction then, two distinct crimes, we've got assault, we've got battery, and they're now separate. Existence is recognised by section 39 of the Criminal Justice Act of 1988. DPP and Little also confirms their separate existence, but they do have, of course, the same maximum sentence, which is 6 months imprisonment or a level 5 fine. Now, to distinguish, the main thing to do is, of course, remember assault requires no touching, but battery requires some form of touching, even if it's indirect. And battery is the least serious of the physical violent offences. So what we're going to do then is we're going to consider the definition of battery. We're going to look for the actus reus of battery and then the mens rea of battery. Starting with, of course, the definition. So then the definition of battery is an act by which a person intentionally or recklessly inflicts unlawful personal violence on another. And this comes from the Law Commission report of legislating the criminal code, which of course, ironically, didn't happen given that this is still a common law offence. But the sentence is provided in section 39 of the Criminal Justice Act of 1988, similarly to assault. And so, in DPP and Taylor, Lord Justice Mann said common assault clearly includes the actual use of unlawful force to a person, which is formally known as battery. In such cases, he said the charge should be that the defendant did assault by beating, and the force applied need not be serious. It does need to be more than the slightest touch, and the victim doesn't even need to be aware of it. But the law is properly reluctant to concern itself with trifles. And in Cole and Turner, as far back as 1704, it was decided that an action for battery, the judge said at least touching of another in anger is battery. So if one uses violence to force his way rudely past the other in a dark alley, for example, then this is battery. So we do see this come through in case law as we discuss going through this video. So we got our definition broadly, but of course we'll stick to sort of an old definition, give it some structure. The actus reus of battery obviously then requires the application of unlawful physical violence or force. And begin with what application looks like. So an application of force can occur in many different ways. It can also be referred to as infliction. So it can be direct or indirect. It must be non-consensual. It must be physical contact as well. And there must be some force, and touching is enough. The force indeed can also be a continuing act. But as we've seen from Cole and Turner, inadvertent physical contact may not be battery. So we look for some case law. Touching of the hem of a skirt in Thomas was enough to be application. Now the defendant was not guilty on appeal, but there was evidence that this could be touching clothes, could be touching person, and that'd be equivalent. In Day, the defendant slashed the claimant's clothes with a knife, and the judge said this was enough. Again, the clothes on the man's back is equivalent to the person in terms of battery. In Collins and Wilcock, in this case, a policeman wanted to question a woman in the street, believing her to be a prostitute, and took hold of the arm. Now, the woman resisted, scratching the policewoman's face, and was charged with assaulting a constable in the execution of a duty. Now, the divisional court said since the policewoman did not claim to have exercising a specific power to stop and search, taking the arm in itself was the assault. So in this case, the policewoman actually committed the assault, and the other person was entitled to use reasonable force in self-defense. So there was no application of force here from the victim to the police officer. So in Wood and DPP, the defendant was charged with assaulting two police officers. Now the technical assault, the battery, when the police officers grabbed the defendant, as they were not arrested at the time, that's when it occurred. The defendant was entitled to struggle until they read him his rights and what have you. Now, of course, these are examples of direct battery, but we have some cases of indirect battery. So when force is applied to the victim indirectly. Now, they're not all battery cases, but what we can see is this battery is a building block to those more serious offences. Now, Scott and Shepherd, this was a civil case in which the court held that the defendant had committed battery when he threw a live squib into a marketplace after two people had picked it up and thrown it further away, injured a third party. So in essence, the indirect act was from the third person throwing it into the crowd or away and injuring that third party. Now the squib, as you can see, is sort of like a firecracker. In Martin, the defendant for a joke switched off the lights in a theatre, put an iron bar across the doorway and shouted fire. Now this caused people to panic and rush out of the theatre, and the defendant was charged with inflicting GBH. Again, the conviction was upheld because the force was applied indirectly. In Fagan and NPC, you're going to look at this case again when we look at different elements, but a police officer told the defendant to park his car in a particular place, and in doing so he accidentally drove onto the policeman's foot. Now he asked the man to remove the car from his foot, but he switched off the engine and refused to move for some time. Now the defendant was charged with assaulting a constable, and his conviction by the magistrate upheld on the basis that there was a deliberate failure to move the car. And the Divisional Court, on appeal, upheld his conviction, but disapproved the reasoning. They said a mere admission to act cannot amount to assault, but there was a continuing act from the time the wheel ran onto the policeman's foot until it was removed, and since it was attention at least in part, it was sufficient. In DPP and K, who was a minor, a 15-year-old schoolboy, the 15-year-old schoolboy left a chemistry lesson to go to the toilet, and he took with him a small amount of concentrated sulfuric acid. He heard someone coming, so he emptied the acid into the upturned nozzle of a hand dryer, meaning to come back and break and clear it away. He put the empty tube in his pocket and returned to the lesson. Now another boy used the toilet, used the hand dryer, and suffered severe facial burns when he pressed the hand dryer on as it squirted at him. Now the defendant was acquitted of an assault occasioning ABH, but the Divisional Court remitted the case with the direction to convict, even though no assault in the ordinary sense had taken place. Now a defendant who pours a dangerous substance into a machine, said that Lord Justice Parker, just as truly assaults the next user of the machine if he had himself switched the machine on. So a good demonstration of what indirect battery can be then. Now in Haysted, the defendant punched the woman in the face, causing her to drop the child she had been holding. Now the child hit his head on the floor, and the defendant was convicted of assault the child by beating, i.e. battery. Now his conviction for the injury sustained by the child was upheld, even though there had been no contact between the defendant and the victim. It was indirect by punching the mum and causing this to happen. Now, of course, battery can also be committed by omission, and this is unusual. Criminal liability can arise by way of an omission as a consequence of a contractual, statutory or common law exception where the defendant has a duty to act. This is rare, but there has been one recent report case, or recent enough. So DPP in Santa Bermudez, we have the victim who was a police officer, asked the defendant to turn out all his pockets, which he did, and the victim asked him if he'd removed everything. He replied yes. She said, "Are you sure there's no needles or sharps on you?" And the defendant said no. And the officer commenced a search. When she put her hand into the pocket, she pricked her finger on a hypodermic needle. Now she noticed the defendant was smirking, and the defendant was convicted of assault by magistrates, but appealed to the Crown Court, successfully arguing it was legally impossible to commit an assault by omission, but this was reversed by a Divisional Court, so he had a duty by statute to tell that there were sharps in the pockets. So once we've considered the application element of the actus reus, we now need to consider whether it was unlawful. So we're going to talk about the unlawful element. So lawful force negates any offensive battery, and of course it's not unlawful if there is implied consent in normal social situations, such as a tap on the shoulder to get an attention, or jostling on public transport, or bumping in corridors at school. So of course we need to be aware of those situations, but if it steps up a little bit, if you're pushing someone to get to a train, for example, that's going to be different than jostling. So once we've established the unlawful element, then we can go on to look at what physical violence or force means. So the physical force or violence element can be satisfied with a touch. It can be satisfied by hostile touching, like in Wilson and Pringle, but there must be some physical contact, and if there's intention or recklessness to do this battery. But there is no requirement for the victim to have suffered any injury or harm, and as long as the contact is unlawful and not warranted or not consensual, then it could be suffice for a battery. So once we've looked at all of these elements, if their application is the force unlawful, and then is it force or violence, then we consider the mens rea of battery. Now the mens rea of battery is applying the unlawful physical force either intentionally or recklessly. So if we look at Venner, the defendant was arrested following a scuffle outside a pub, and he kicked out wildly, struck a policeman, breaking a small bone in his hand, and the defendant was convicted of assaulting a constable, and his conviction was upheld by the Court of Appeal. Now, the offence of common assault, they said, requires intention to cause the victim to apprehend immediate and unlawful personal violence, or indeed recklessness as to whether such apprehension is caused, or intention or recklessness as to the application of force. So the mens rea then is quite straightforward for battery. We either have a direct intention to apply unlawful force, or we have oblique intention, so it's a virtual certainty the force is going to be applied and the defendant knows it, or indeed recklessness. The defendant appreciates there's a risk of applying unlawful force and takes this risk anyway. And we use Cunningham to support that. Now, assault and battery, we must remember, are offences of basic intent, which means if the defendant is intoxicated during the commission of the offence, they may be considered reckless. So it might look like they have drunken intent, but that then becomes recklessness. And we'll look at this in the intoxication video. But the key case here is DPP and Majeski. So he attacked the landlord of a pub. When the police officers were called, they attacked them too. And the House of Lords held that becoming intoxicated is a reckless course of conduct, and provided the crime is one of basic intent, then the defendant will have formed the mens rea for it. Okay, so that's the overview of battery. So we looked at the definition, we looked at the constituent elements for the actus reus, and indeed the mens rea. Thanks for watching.